Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employer charges an employee twice for the same incident. What does the principle of double jeopardy mean? Now, double jeopardy occurs when employees punish twice for the same incident of misconduct. Normally, such discipline would be found to be unfair. However, a second disciplinary process based on the same incident or events may be justified in certain circumstances. The question is just when. Now, the matter that I want to discuss is Sambu on behalf of A.N. Malatsi versus the Gartsibande District Municipality. In this case, the employee was employed by the municipality in its finance department. The employer was alerted by its bank of possible fraudulent activities, and an investigation uncovered irregularities that exposed the employer to a potential loss of approximately 9.7 million rand. The investigation found that there were several attempts made from the employee's computer to illicitly access monies held in the employer's bank account. The employee was charged with a failure to conduct himself with honesty and integrity, in that he attempted to access the employer's bank account on 11 different occasions. There was also an alternative charge of fraud. The employee was found guilty and was dismissed, and aggrieved by the outcome, he referred an unfair dismissal dispute to the bargaining council. At the bargaining council, the arbitrator found that the employee's sharing of his password was very irresponsible, but it would be too harsh to dismiss him in circumstances where there was no evidence to conclude that it was indeed the employee who had attempted to access the bank account. The dismissal was accordingly found to be unfair, and the employee was reinstated. Now, after his reinstatement, the municipality issued him with a second notice to attend a disciplinary hearing, this time charging him with gross dishonesty, in that he acted dishonestly with the intention to deceive the municipality by sharing his own computer-created password with other employees, which resulted in his computer being used for fraudulent activities. The second charge against the employee was a failure to comply with the municipality's IT policy by sharing his computer password with other employees, resulting in his computer being used to conduct fraudulent activities. After the second hearing, the employee was dismissed, and his dismissal was found to be fair in a subsequent unfair dismissal dispute referred to the bargaining council. The employee then applied to the Labour Court to review and set aside the second arbitration award. At the Labour Court, the employee contended that the employer conducted a second disciplinary hearing based on the same facts that led to their initial guilty verdict and dismissal. He argued that being dismissed for a second time amounted to double punishment, since the first arbitrator had determined that the period between dismissal and reinstatement should be treated as unpaid suspension. This is what the court found. After examining the relevant legal precedents, the court clarified that in the context of labor law, the principle of double jeopardy does not automatically prevent the employer from holding another disciplinary hearing or imposing a more severe penalty, including dismissal, for the same offence. The decisive factor, according to the court, was fairness, meaning that a second disciplinary hearing would only be justified if the circumstances warranted it. Now, the court found that the charges in the second hearing arose from the information that the employer did not possess during the first hearing, specifically related to the sharing of passwords. This information only came to light through the employee's testimony in the first arbitration. Additionally, the court noted that the charges in the two hearings were different. The first hearing focused on attempts to access the employer's bank account, while the second hearing centered on password sharing and failure to comply with the employer's IT policy. These actions resulted in the employee's computer being used for fraudulent activities, posing a risk to the employer. In the end, the court deemed the employee's interpretation of the first arbitration award and the reliance on the defense of double jeopardy as opportunistic. Consequently, the court ruled against the employee in this matter. The municipality was therefore justified in dismissing the applicant for sharing his password and for breaching its IT policy, and its conduct in doing so was not in bad faith. So, ladies and gentlemen, in conclusion, the court in this matter emphasized that fairness is the standard by which an employee's action should be assessed when considering double jeopardy claims. It would be unfair to prevent an employer from holding a second disciplinary hearing if they obtain new significant evidence that could have influenced the outcome or punishment of the initial hearing. Furthermore, the defense of double jeopardy does not apply when the charges in the two disciplinary hearings are different, even if they stem from the same facts or events. Now, to avoid repetition, employers should ensure that the charges are distinct and that additional evidence is available to support the accusations. That then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email us at info@masconsulting.co.za. If you are interested in staying up to date with the latest news and insights on employment law, be sure to subscribe to our YouTube and Spotify channels. Thanks again for tuning in. I'll see you next time. Bye-bye.